I'm Rodger Citron. I'm a professor at Touro University, Jacob D. Fuchsberg Law Center. This is a Touro Law Review podcast, and we're delighted tonight. Our guest is Jessica Silbey. She is an associate dean and a professor at Boston University School of Law, and where she teaches, among other things, the constitutional law course. We are going to talk tonight about the Supreme Court case decided on the last day of the Supreme Court term earlier this summer. It's the CASA case involving universal injunctions. And with all of that said, thank you, Jessica, for joining us tonight.
I'm happy to have this conversation with you.
All right. And we always begin with, can you tell us a little bit about yourself?
Sure. So everything you said was right. I studied law at University of Michigan, where I also got a PhD in comparative literature, and that part of my background is important to me. I'm like a law and humanities person. I think a lot about storytelling and narrative and the way law makes meaning. I teach intellectual property as well as con law, and I love that aspect of my work. Before I was at BU, I was at Northeastern School of Law, and also before that at Suffolk. And so I've made my rounds around Boston and feel very connected to this area. I'll just say also I was a law clerk for several years in the federal bench and feel particularly defensive of district courts, where I spent much of my time.
May I ask, just one judge?
So Judge Robert Keaton at the district court, and he was a mentor for me for a long time. And then at the First Circuit Court of Appeals with Judge Levin Campbell, who is still alive and still a regular conversant with me at the age of 99.
It's tremendous.
Yeah.
And then we're going to talk about the universal injunctions case. And can I ask you to sort of set the table for us or set the stage for our listeners about what the case was about?
Sure. So I could go into a lot of depth, but let me be as brief as possible. So on January 20th, the first day that Trump was in office, he signed an executive order that had a title, Protecting the Meaning and Value of American Citizenship. I think the title is important. As I said, I'm a narrative person, and he's starting with a story there. It quotes the 14th Amendment, which, as everyone should know, says that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. And then it directs that pursuant to its interpretation of that language, the executives, no department shall issue documents recognizing citizenship to anybody who was born of a mother who was unlawfully in the United States, or if that person's mother was present in the United States lawfully but temporarily, and assuming the father was not a U.S. citizen. So it basically guts birthright citizenship or limits it to sort of other situations. It goes against longstanding practice in the United States and understanding of what the 14th Amendment means and why it was put there. So immediately lawsuits were filed, as one imagines would be, at the district courts, several district courts around the country. The plaintiffs were not only pregnant women and collective groups of pregnant women organized by nonprofits, but also states. So several states, 22 states and 2 cities actually sued because they would be burdened by this, not knowing who's a citizen and who's not, having to pay benefits. And I mean, that there was a lot of what people call pocketbook expenses to figure out the cost of citizenship or non-citizenship. Anyway, district courts immediately enjoined the application of this order, saying that it was blatantly constitutional. One judge in Western District of Washington, a Reagan appointee, one might add, said it was blatantly unconstitutional. And then 3 courts of appeals, the First Circuit, the Fourth Circuit, and the Ninth Circuit, rejected the United States government's appeals to lift those injunctions. And those injunctions purported to apply nationwide, in part because states didn't know when people were moving full faith and credit issues about if you're born in Missouri and you move to Washington, things like that. So it was a nationwide injunction, and the court agreed to hear the case. The Supreme Court agreed to hear the case. Now the trick, what Justice Sotomayor calls gamesmanship, in her dissent, the trick would be that the United States government did not seek an appeal on the merits of the EO's interpretation of the 14th Amendment. It just sought appeal on the scope of relief, that is, the nationwide injunction. That is the idea that the district courts could not enjoin the application of that EO to anybody in the United States, only to the people who had sued, only to the parties in the case. And so that's the question that was teed up for the court.
Yes, yes. And I think we just want to sort of run through to the court actually did hold oral argument in the case, I believe, which even
Yeah,
though it was on this expedited, I don't know if it
yeah,
was.
they held argument. The argument was in May, I think. And the decision was issued at, as you said, the very last day of the last day of the oral argument term, right? So do you want me to say something about what the court majority said?
Yeah, I think if it's okay, we
Yeah,
just need to
yeah,
sort
no,
of
I'd be happy to.
understand
Yeah, yeah,
as we say to our students, the
yeah,
holding
yeah, yeah.
and the vote tally.
Right. So, I mean, it's hard for me to describe this case without also being critical of it. So I'm just going to flag that. That's the way I teach con law. I don't teach it without a framework of like, I mean, all these cases are up for interpretation. Anyway, so what the court wrote, so it was a 6-3 decision, ostensibly. Justice Barrett, interestingly enough, the most junior justice in the majority, wrote the opinion. That is unusual. Um, and she wrote the opinion. There were concurrences by Alito, Kavanaugh, and Thomas. So the folks that joined Barrett without comment were only Gorsuch and Roberts. Do I have that right? Yeah. So that's interesting. I think that's interesting because there's some disagreement among the concurrences, I think. And what Barrett said was the scope of district court's equitable relief to grant remedies that are creative and that complete the relief for the parties in the case is confined to the kind of equitable remedies that the district courts were granted when they were given equity jurisdiction in 1789 under the Judiciary Act. And so what she does is by now a very familiar move at the Supreme Court, which is confine the scope of power to the history and tradition that grounds the statutory enactment in this case, or might otherwise ground a constitutional provision, for example. And so I just want to say, here's my critique, is that she limits, and she says the courts, in this case, nationwide injunctions have no history or tradition. That's what she says. There's pretty good evidence that she's incorrect about that, at least as we might define nationwide injunctions. And she says that in this case, the scope of relief was arguably too broad. The government has a likelihood of success on the merits. Remember, this was a PI with regard to that scope of relief. And they're sending it back to the district courts to craft a narrower injunction, if that is possible, to give the parties before the court complete relief. So there's a lot of wiggle room in this case, I just want to say, for the parties to get what they want, as well as the states to get what they want, maybe everyone else to get what they want, who thinks that natural born citizenship is what the Constitution commands. But what they're doing is sweeping away the idea that district courts can just enjoin an executive order, in this case, with one decision, like win one once, blanket the nation everywhere. That was the concern. And I just want to say about Barrett's decision. I mean, I have a lot of things and we could talk about this, but she redefines the question presented in this case as whether Congress has granted federal courts the authority to universally enjoin enforcement of an executive policy. She's very technical, very formalistic, very methodical about her decision. And it reads sort of like I would say, sort of a faux history of the Judiciary Act. And she really narrows the question presented in this way. And as a person who's taught con law, well, her whole career, it reminded me of a terrible, terrible case called Dred Scott against Sanford, where Chief Justice Taney redefined the question presented in that case to be a jurisdictional issue. Does the court have jurisdiction to even hear the case in the first place, when the case was about the freedom of this man who had been born in the United States but enslaved? And redefining the question presented in Taney's case just so distorts sort of the humanity behind what's going on in that case. And I just couldn't help but draw that analogy in this situation. Like, I just feel like her needle, threading the needle of what's at issue in this case just reminded me of Taney's move in that decision.
So I have a ton of questions,
Yeah.
but let's take them one at a time, as they say. Because you mentioned Dred Scott, you weren't the only person to see such a parallel,
Oh.
because Justice Sotomayor,
Oh, right.
right out of in her dissent, also invokes that case and you know everything that's sort of problematic or troubling or worse about that case. So I wanted to give you a chance. I'll ask it this way, which is, how did Justice Sotomayor um, see the case? And of course, Justice Jackson, I believe, also wrote a dissent. But
Yeah. So, I mean, Jackson and Sotomayor clearly were working together on what part of the counter argument they were going to attack. And Jackson calls that out actually in her dissent. She says, I'm not doing that part of it. That's what Sotomayor is doing. I'm doing this other part of the talkback. And but both of them quite clearly say there's a lot at stake here and you're hiding the ball. I mean, they don't use the term gaslighting, but they really do act like, you majority act like this isn't a big deal and we're just doing this little jurisdictional thing. But I mean, Jackson calls this an existential threat to the rule of law, which I can understand why she says that. And Sotomayor invokes Dred Scott in part because it was such a stain on the court. And I'd say because Taney's, like, I think it was over 200-page decision, which was withheld from the dissenters for months and months because he was so defensively trying to counter their arguments, that Taney's majority opinion was just so relentlessly avoiding the issue at stake, which was, whether slavery is actually something that we should be abolishing in the United States, and whether Congress has the power to do that with the Missouri Compromise. Her invocation of Dred Scott was to remind everyone that the 14th Amendment was put there to undo the stain of the Taney decision. And so Sotomayor is invoking Taney as a substantive matter, I think, that case as a substantive matter. Like, let's not forget our history. Well, Jackson's dissent, sorry, is much more of an exegesis on the rule of law and what the role of judges are. And on that point, I just want to say the other aspect of Barrett's decision that reminded me of Chief Justice Taney decision is where, so Justice Taney, I don't know if students will remember this or this is pointed out to you, but Taney says something that it would abrogate the judicial character of the court to reach this issue when we do not have jurisdiction. Like justice or injustice, that's not our decision. We don't do that. We just decide laws, the constitutionality of a law. And that just sounds so much like what Barrett is saying. Like, stop getting all worried about everything. We're just doing our little role here. And she evokes this idea of judicial humility. And then she accuses Jackson of being the imperial judiciary. And I was like, this court is anything but humble. I mean, the majority in this court has been engaging in a constitutional revolution that rivals the Warren Court, if I want to be fair about it. Like it's really engaging in a constitutional revolution. There's no humility at all. So for her to say that we're just dealing with a historical jurisdictional matter just feels really beyond the pale to me.
So, and so here's the next question, because I feel like we really, I mean, you have sort of laid it all out for us, and now I want to try and sort of, analyze, understand the first thing, and I don't, I don't know that I have an answer for myself, but why, if you're the Supreme Court, why did you pick this case
Yeah.
to be the universal injunctions case where it seems like it's so clear on the merits? That is to say that the executive order won't survive review. Um,
Yeah.
and yet, this is the case you pick to address this remedial issue or point.
It's I at first, when they picked this case to decide this issue, thought, oh, they're going to split the baby. They're going to say, well, clearly in this case, universal injunctions are fine, but in most all other cases, they are not. Because this is I mean, this is a preliminary injunction question. The likelihood of success on the merits of the issue are what's at stake. And it just seems so like this is not a hard constitutional question. But I have to say, now that I've read the opinion and I've started, studying more about what I think are off the wall arguments about whether birthright citizenship can be narrowed in the way that the executive order has described it, I'm actually a little worried that this is a signal that this is not an easy question for this court. Um, and uh, and that there may be it wouldn't be 9-0 that birthright citizenship is as we've always thought it was. And um, given that this is a different kind of splitting the baby. I think there's a lot of talk, and I'm sure people who've been reading the blogs and stuff will recognize this, but there's talk that they could have decided the universal injunction question under under Biden's presidency. There were so many opportunities to say universal injunctions are no good. You can't, to write the exact same opinion with regard to a student loan issue or with regard to debt financing or whatever. But they didn't do it under Biden, and people are cynically saying it's because they wanted those policies enjoined. And so now they have the opportunity to enjoin to basically lift the stay of a policy that feels like it's profoundly unconstitutional. And I think, well, maybe it's because they like this policy, so I am of many minds on why they took this case, and it's been shifting over time. It's a terrible case in which to say that universal injunctions are inappropriate. I mean, it's just a terrible case for that. I mean, as a practical matter, just think about what it would mean for different jurisdictions to have different rules and practices about whether babies born in the hospitals there are citizens or not. I mean, on any ground, whether we're talking about immigration and citizenship, we're talking about issues like that, like nationwide rulings are super important. And so it really does feel like the wrong case for that. And I think Kavanaugh's concurrence makes that pretty clear. That's where his concurrence was the one that felt a little bit like not fully on board with what was going on, although he did join his friend Amy Coney Barrett.
So, um, so I was I've been accused or said to be by a teaching assistant I had in college. We were talking about the book All the President's Men, and the TA said, when I said something about like, oh, well, I feel like the way this book is written, it's as if Woodward and Bernstein are trying to reconstruct the challenge of trying to understand what was going on in Watergate. To which my TA said, that's a very sympathetic reading. He's like, I think this book was put together very quickly, uh, and that's why it's a little bit hard to tell what's going on
Right, right, right.
throughout most of it. So, in that spirit, in that light, that is understanding, my tendencies or predilections interpretively. Um, what about this idea, which is that because we now have, I mean, one of the things that we benefit from in that we're talking about I guess a month, maybe a little more than a month after the term ended, maybe whatever, about a month
Yeah,
after the term ended, is that in fact there have been developments in the lower courts
yeah,
um, following up on some of the suggestions.
yeah,
And is it all possible, that is, in taking a case um, in which it seems like the merits were so clear that this would in fact somehow sort of facilitate the opportunity to develop a, post-universal injunctions jurisprudence taking advantage of procedural vehicles like the class action and so on. Um, no wrong ideas in brainstorming or podcasting.
yeah.
It's just a thought.
Well, I mean, that's very optimistic of you. And
That is,
I appreciate that. In the times we're living, I will take any optimism I can get. So, um, for sure, I mean, so I think I can tell a story where the history and tradition modality is not something they're going to distance themselves from. They're going to do it in this case anyway. They did create lots of gaps and holes, like as you said. I mean, first of all, the remedy of nationwide injunction was only analyzed under the Judiciary Act, not on constitutional grounds or on prudential grounds. So it's purely a question of statutory authority. And Amy Coney Barrett made that clear. The footnotes are where all the work is. I mean, I just want to say in all of the opinions. And so this is just a question of the Judiciary Act. Congress could come back and amend it tomorrow if they wanted to. Um, so yes, so it could be pushing issues to other branches of government if that's what they want. Um, it it is a roadmap for class actions. Um, I want to say that Alito's concurrence, sort of shakes his finger at readers in district courts, like, don't think that you can get around this ruling by making class certification easy. We've already said class certification should be hard. So I feel a little bit worried about that. But yes, I mean, the district courts have already granted class certification. That's already happened. Yeah, there's the opportunity. I think Barrett said in also a footnote the APA remedy also. So right, there are other procedure. That's the wonderful thing about procedure. I'm not a proceduralist, but you can often get to the same result in a different way. So then you might wonder, what was the point of this if you could do that? And if I'm just going to be cynical, you're going to be the optimist, I'll play the cynic. I think the point of that is to close down those avenues also. I just want to say that's what I think is
oh,
going on.
this
But
is the opening act.
yeah,
Yeah.
I am no longer whether it will succeed or not, I don't know. But class actions are hard. They're usually for money. They're not usually for injunctions. It just feels, but um, this could end up being a nothing burger in that way. Um, Although it feels very cruel as a nothing burger.
So, um, second, sort of, when we were talking through the case, um, I guess I just want to go straight to the Justice Barrett question because you even sort of you flagged that um, here we are, it's the last day of the term, and there's always this really, I think, actual significance to they save the hardest for last or the most important
Yeah.
for last, or certainly tend to do that. And yet, here's the most junior justice um, writing a case that is really, at the intersection of some of the most important issues in law and politics today. And that is, what did you make of the assignment? And
Yeah.
then we've talked through the opinion to some extent, and I agree with your characterization of it as technical and formalistic. Um, but it's also the case. I know this is a compound question, so it's highly
Yeah.
objectionable. But she didn't go out of her way to answer every question, right?
Oh, yeah. Yeah. Yeah.
So
Right.
yes,
Okay.
I'll
So,
stop
so
with two or
I'll
three
say the
questions.
second part. It is
Yeah.
not a great opinion in that it does not respond to the dissents in the way that one would hope it would. So, I mean, I love teaching, for example, U.S. against Virginia in con law, where Scalia's dissent speaks directly to Ginsburg's majority and back and forth and back and forth. And it's just this wonderful, like, fencing match. And Ginsburg went on record saying how her opinion was gotten better because Scalia kept pushing her, and they talked through their objections, even though Scalia's dissent was so, vociferous. This majority opinion does not do that with the dissents, and it's almost like below the belt, like jabs at Jackson for sort of not understanding what's really at stake, and it seems a little personal. Actually, I thought it was a little, and so one could say it was rushed. Maybe, I mean, it was between May and June. It was only about 6 weeks to write the opinion. That's not a long time to write a really important opinion. Um, and so it doesn't do, I don't think it does justice to all the arguments that one could make. I think it might explain the narrowness. Like she kept saying it's a narrow opinion. We're just doing this one thing. And so then she could push all the other stuff off to the side. Why was she the one doing it? She's a proceduralist. She was a law professor for a long time. She taught civil procedure. I don't know if people notice reading the opinion. She cites a lot of Notre Dame law professors and their law reviews. There's a little battle of the law reviews going on in the decision. And so I think, she knows this stuff. She feels comfortable about writing about what the Bill of Peace is. And I, uh, you know, I gather Gorsuch would have written a different opinion, and Roberts might not have wanted to be the person writing this. I mean, I don't have a lot of faith in Roberts to move this court much right now, but I have seen him um, try to moderate. I'm thinking about the ACA case and the health Obamacare case. I get the sense that he might have written a different opinion too. Like, this just feels like it's covered in plastic a little bit. Like, she's all wrapped up with a bow, and maybe they just wanted to project that. I don't know. I mean, I'm
Mhm.
just spitballing. I don't know. Um,
Yeah, the Justice Barrett does seem to be, uh, you know, perhaps because she's the newest justice, but there's something intriguing, right? Where sort of there's this idea of, um, getting a sense of her identity as a justice, and that was even a little bit, relatively speaking, in play this year because I think early on in the emergency docket, um, she voted, I think, to uphold lower court orders that I think there were two cases where she, supported the entry of the order against the administration. Um, it now seems that those were more the aberration and not the norm. That is to say, since then, that it's the view of her as a conservative, very conservative, depending upon your perspective, seems to be um, fairly steady, constant, settled, however that seems to be. Do you think any of that's going on, or is that's like the bloggers
yeah, I
speculating?
don't. I mean, so law professors are a small crowd. We've all, I mean, I've been in the room with her when she was a professor. I have friends who taught at Notre Dame. So I mean, I think she's a very, very smart and conscientious uh, scholar and jurist. And so I'm not gonna, I mean, but I think there is a sense in which, I mean, I'll say, like during the oral argument, I liked how she pushed General Sauer. She said, "You're resisting Justice Kagan's answer. I want to hear more." Like there's a tension in your. This is when Sauer refused to acknowledge that they would follow a rule of the circuit in the Second Circuit, and he said, sometimes most of the time we do. It's the general position of the district of the DOJ that we will follow the rule of circuit, but not always. And then there was some like you're not going to follow, you're not going to do what a court says. And then there was some tension, and he was avoiding, I think, answering Kagan's question. And Barrett went in and said, "I'm going back to that." And so I sometimes hear these oral arguments, and I listen to them all the time. That she's trying to uphold the integrity of the back and forth and the arguments. And both Sotomayor and Barrett quoted that engagement, that colloquy between Sauer and them in almost like, remember you said it. You would follow a rule if we issued it. And so I point that out as I think Barrett, my armchair psychoanalysis here is that Justice Barrett has lived in a very cloistered world. And, she has a large family and has been at Notre Dame for a long time, and then was on the Seventh Circuit. And the kind of what she might think is like hysteria about rule of law and democratic deficit and the executive taking over. I think she just doesn't buy into that. She is like, I know how to run a calm ship. I know how to answer the questions. I'm controlling the environment. And this decision feels like that's this narrow, there's no emergency here, right? And that's what it feels like to me. It's like she's trying to say that there's, Justice Jackson, you're hysterical, And I'm like, a lot of us around here are thinking things have gotten pretty bad, but somehow you don't think it's so bad. Why? Why don't you think it's so bad? And my sense is she doesn't think it's so bad because she's not experiencing it as so bad, because her life has been in a certain way and she's controlled it in a certain way. I mean, that's just my best. I don't know if that's true, but if you ask me to guess, that's what I think is going on in this opinion.
Yes, no, I appreciate the understanding that it's a speculative answer, because that's all we can do, based upon the text of what's written and so on. I will
And let me
say that,
just say, Rodger, history is never that straightforward. The idea, she writes this beautiful, wrapped up decision about the Bill of Peace. And I mean, you have this experience of I guess class actions came directly from bills of peace. It's the child of that action. And then you read Sotomayor's dissent, and this is exactly what students should experience when they read great decisions. All of a sudden, everything that you just read unravels. I thought I was just told this. And then it turns out that there's a common anchor, but it's bills of peace and different kinds of equitable remedy. I mean, it's class actions and different kinds of equitable remedies, and it's just much more complicated. And so you feel a little resentful when you're told the story about what this is, and then actually you're just making that up. You're making it sound good, but it's actually more complicated than that. And that's the way I feel about this moment. It's it's complicated and it's scary, and she's telling us all to be calm.
I was going to say that, you were talking about the oral argument exchange, which I recall, reading about, and that was like the peak moment for, oh, she might be Justice Souter, like this at the stock.
Yes, right.
And then of course it really did sort of,
Yeah.
normalize, if you want to say that, or decline, depending upon, again, on your perspective. We've I think we do have to touch on. I know we've gone some length here on the opinion, which I think has been great. I think Justice Kavanaugh's concurrence deserves a little bit more airing, um, partly because um, you know he's known, at least in my experience. I don't teach constitutional law, but certainly the big cases, you read the big cases, he's known for doing these concurrences where he sort of steps, sort of like pulls back, writes a short concurrence about, let's keep things in perspective. And
Right.
he did it in Dobbs and he did it in Bruin. Here, he actually, in the concurrence, he's doing some of that. He's doing some of that, but he's also sort of really sketching out, right, a post-decision landscape for how things could work now. And seems reasonable, seems plausible. The part that I still sort of get stuck on personally is um, you're going to be even busier on the shadow docket. That is
He says
good fun.
that quiet part out loud. It's like, just come to us. We'll decide all the cases for you.
Um, and so, yeah, like, well, I can do it since we're videotaping, right? Like,
Yeah,
um,
right. I mean, right. I mean, talk about imperial court. I mean, it was amazing to me to read that. I mean, I immediately started calling my colleague Jed Sugarman, who's on my faculty, who's a federal courts and a constitutional historian. I was like, did he actually write that? Am I reading that right? But one of the things that's interesting about Kavanaugh's concurrence also, I mean, he does have those qualities that you mentioned before, this sort of he's like the coach, like, don't worry, we're going to manage this, it's going to be fine, it's not as bad as you think, we're just making this about democracy even while we're stripping you of your bodily autonomy. um uh he keeps repeating the phrase in the concurrence that that this is not altering the traditional role of courts. And going forward, he says, in the wake of major new federal statute or executive action, maybe injunctions will be appropriate. Like, and you'll have to do it on an interim basis. Like, he kept saying major new federal statutes or executive action. It was as if they were crafting, he was saying, the rule we just wrote for today is only in these very specific circumstances, like when Donald Trump is president or when Biden is president or whatever. I mean, like, I wasn't quite sure, but it reflected back on the major questions doctrine, which he has been a big part of as well, that there's a sense in which when something really big is happening, maybe all the normal rules are off and but this is not one of those major things. I kept saying, like, this isn't one of those. This is one of those major moments. And so everything he said, I was sort of on board with, except for the shadow docket stuff. I mean, but like the idea that there are reasons why nationwide injunctions make sense and all that. And then I thought it perfectly should have concluded, and this is one of those moments, but that's not what it concluded as. Um, and so I guess I did read him as being someone who, on the merits, thinks the executive order is unconstitutional. I did, in all of this, I thought he thinks the executive order is unconstitutional. Um, and I gather Roberts probably thinks so too. But that's only five. And who wants to write a 5-4 opinion on something of such magnitude as what does that phrase mean? Like, there's just no way they're writing that opinion. And so again, I go back to, this was a dodge in many ways. This was a way not to have to write a split opinion on something so critical and just make it on this like little procedural question that's been nagging at them for so long.
Yeah, yeah. It, well, I hate to resort to the cliche of we'll see.
Yeah.
I'm reminded though, and this is, that Roberts tends to tends to step up and take the 5-4s. Um, And I'm even thinking of sort of, the subpoena cases. I think that is, he wrote, I guess one of them was 7-2, not 5-4. But anyway, that's a long
Yeah,
time ago, relatively speaking.
yeah, yeah.
Um,
Um, yeah, you do wonder. It'd be nice to know what's really going on back there. Um, I mean, Justice Roberts must have the worst job. I mean, this court is gonna, I mean, if things, I mean, no matter how things go, he's going to be remembered as presiding over this court, you know.
yes, yes, I know, and personally, I can still recall his confirmation hearings. I thought he was dazzling at his confirmation hearings all those many 20 years ago, I guess it
Yeah,
was more or less.
2005. Yeah.
And he very much self-consciously casts himself as, I'm playing the long game, the institution, and uh, the, we're maybe halfway, maybe a little bit more than halfway through his tenure as Chief Justice. So it's
Well, we'll see.
his
I know.
legacy is still being written. I have one last question
Yeah.
or topic, and this is kind of um, this is the neutral principles question.
Oh,
Um,
yeah.
which is, constitutional law. This is, I think, true certainly when I was a student, perhaps when you were too, I would imagine. Right? In other words, it's the sort of the most contentious class in the curriculum because, the issues are close to one's passions quite often. Um, there can be, the intersection of law and politics can sometimes be hard to discern or distinguish. People have strong feelings about constitutional law. And, you've said, as we've talked tonight, that in effect, we're seeing, you know, uh, a conservative version of the Warren Court in its ambitions, um, and in some of its jurisprudence. Um, so let me just come back to, you know, when you teach, how do you handle the neutral principles issue? It's a phrase that, of course, goes back well into the last century, but I'm curious about how you deal with the issue in this century with your students.
Well, I teach the Constitution very much as um, a literary document, and by that I mean, it has a form and it has words with meaning, and it was consciously put together, but meant to live well beyond its time. And it talks about certain things and not about other things. And so, like, I tell the students, like, does the Constitution say anything about whether you can eat ice cream tomorrow? The answer is no. Constitution says nothing about that. Does the Constitution say anything about equality? The answer is yes. It does say something about equality. Um, and so there are things that are in the Constitution and things that are not in the Constitution. And so I don't believe in the idea of neutral principles. I mean, the Constitution has substance, it has substance. And so, that substance, like the scope of the substance can be debatable and it can change its valence depending on the kind of situation that it's arising in. But like and so one of the main questions, the first question I ask students is, does the Constitution prioritize freedom or equality? Does it pit them against each other? Is there a way to understand the relationship between freedom and equality based on the document? And it's a very interesting conversation because equality doesn't enter the debate until the 14th Amendment. Freedom was there in the preamble, and if we understand the history of the Constitution, it was one of the reasons we have the Constitution. Separation of powers was to maximize individual liberty in fear of a concentration of power in any one branch of government. And so students sort of fall into the liberty comes first, and equality comes second. And then by the time we get to the end of the class, they realize that you can't have freedom without equality. Like, they have to coexist. Like, the way the doctrine and the way we experience freedom, real freedom, the way we think about what it means to be free today, it demands a kind of equal treatment. And so, so if you're asking me about neutral principles, what I would say is the Constitution has values baked into it. It and it had aspirations. It's an aspirational document. It had hope for a future. That's substantive too. And so I just don't I don't I don't think you can like I think interpreting the 14th Amendment's citizenship clause to produce hierarchies of people in the United States, to produce what we might call caste, violates the value of the Constitution, which is the idea of equality between people, not citizens necessarily, between people with regard to certain fundamental rights. And so, like, I think that's clearly a value baked into the Constitution, and so there's no neutrality with regard to that. That's what it is. I think equal citizenship is just pretty clearly a value. So I just neutrality triggers me in that way.
Uh-huh. And I'm really only smiling because I think I'm a little bit older than you. Um, and so I was at the tail end of when I took constitutional law of they were still talking about John Hart Ely and
Yeah.
democracy and distrust and this procedural understanding of the Constitution. And I have a colleague on the faculty, again, a little bit younger than me, um, and we were co-teaching a seminar class one time, and he responded quite making a number of points along the lines you suggested. And I think I don't know how much it sunk in with the students immediately. And so I paused and I said, do you understand our disagreement? And I really want to be clear. Um, my colleague's Professor Jorge Roig. I said, Professor Roig, I mean, he's calling me a coward because he's saying, don't hide behind procedure. That is that the Constitution is committed to certain substantive values. And, you know, I'm sure there's more to it than a generational explanation.
Yeah.
That is,
Well,
I'm
I
sure
mean,
there's
right.
there's
I
a lot of
mean,
pieces
so
to it. But
yeah,
yes, go
Jorge
ahead.
is a lovely scholar. I mean, there are aspects. I mean, I think the dichotomy or the what we sometimes say there's procedural issues and there's substantive issues. All students understand that, like, or they should anyway, that those things are not separate, right? I mean, they're just not. Um, but for sure, the Constitution also creates rules by which to debate the scope of the values we're talking about. So, what equal treatment means is a debatable question in different contexts. That equal treatment is demanded by the 14th Amendment is not debatable. How we debate these issues is set up by our constitutional structure and the statutes that are enacted under it and by the judges that enforce those statutes. So, like, there are rules of the game that the Constitution sets up. And if by that you mean, like, I care very much about protecting those procedural issues, and what might come as long as the procedure is followed will be fine, you know, fine, except that through those procedural mechanisms, we could also issue an unconstitutional order, right? So I agree with you. And one of the things that is upsetting me deeply about this moment too is I do worry that the court is changing the rules of the game without being clear about it. And so by accumulating power in the president, by blessing all these executive orders, for example, not letting courts enjoin them when they violate the supreme law of the land, I feel like they are rigging a system that was otherwise a little bit easier for everyone to play fairly. And now it's less fair, it feels. And so, um, you know, fair rules is a substantive value. Let's just put it that way. And I don't like the idea of political gerrymanders enabling, Congress to always be one way. Like, there's just a lot of things that this court is allowing to happen under the nose of constitutional adjudication. uh, the Constitution doesn't solve all our problems, that's for sure. But it definitely does have substantive values.
All right. This is really, we've gone for nearly an hour. And, you know, last word or words, would you, anything more that we haven't touched upon?
Well, I guess what I'd say for students who are listening, one of my other jobs at BU is to be the faculty clerkship advisor, and so I'll just return to this. I think one of the most wonderful postgraduate jobs one a student could have is to work for a judge, whether it's a state judge or a federal judge or administrative law judge. Anybody, I think getting behind the scenes and seeing how these decisions are adjudicated is a wonderful, wonderful way to start a career. And we do a lot of reading and parsing of these decisions for the rest of our careers. Getting in there early to see how they're written is really a joy and very worthwhile. So I would just speak directly to students and say, try to do that.
No, I appreciate that. I play a similar role here at the law school. And so, as they say in the Supreme Court, I join your opinion on the value of the clerkship. So,
Great.
thank you so much. It's been a
All
pleasure.
right, it's been a pleasure. Yeah.